Ready? 3, 2, 1, start. This adjudicating authority, on perusal of the documents filed by the creditor, is of the view that the corporate debtor defaulted in repaying the loan availed and also placed the name of the insolvency resolution professional to act as interim resolution professional, and there being no disciplinary proceedings pending against the proposed resolution professional. Therefore, the application under subsection 2 of section 7 is taken as complete. Stop. Accordingly, the adjudicating authority NCLT admitted the application for consideration, passed necessary order of moratorium, and appointed the interim resolution professional. Stop. Aggrieved by the aforesaid order dated 9/8/2018, the appellant erstwhile director of the corporate debtor approached the National Company Law Appellate Tribunal in Company Appeal number 549 of 2018 under section 61 of the Code, challenging admission of the application made by the respondent number 2. Stop. The appeal so filed by the appellant was considered and summarily dismissed by the appellate tribunal by way of its order dated 17/9/2018. Stop. The appellate tribunal took note of the contention urged on behalf of the appellant that a petition under section 19 of the Act of 1993 was pending before DRT, wherein question had been raised as to whether the amount was payable to the assignee or not. Stop. As regards this, the appellate tribunal observed that initiation of CIRP cannot be annulled merely for pendency of a petition under section 19 of the Act of 1993, and in terms of section 14 of the Code, all such pending matters cannot proceed during the period of moratorium. Stop. It was also contended on behalf of the appellant that there was no debt payable. Stop. After noticing this contention, the appellate tribunal called upon the appellant to file an affidavit that no amount was received or the amount received had already been paid, and therefore there was no debt or default. Stop. In response, learned counsel for the appellant expressed inability to file any such affidavit for the reason that the corporate debtor had indeed availed the loan from the bank. Stop. After noticing this stand of the appellant, the appellate tribunal felt disinclined to interfere with the order passed by the adjudicating authority and hence dismissed the appeal while observing as under para. Learned counsel appearing on behalf of the appellant submitted that a petition under section 19 of the Recovery of Debts due to Banks and Financial Institutions Act 1993 is pending before Debt Recovery Tribunal, Aurangabad. Stop. Wherein question has been raised is whether the amount is payable to the assignee or not. Over.